Aye.
Thank you for having me. My name is Robert Yablon, and I am an associate professor at UW Law School. I co-direct the law school's State Democracy Research Initiative, and I'm a faculty affiliate with the university's Elections Research Center. My academic research focuses on election law, including redistricting. Redistricting is one of the most consequential tasks that members of this body perform. The decisions made in the coming weeks and months about where to draw the lines will shape who governs this state and how it will be governed for the next 10 years. Unfortunately, if Wisconsinites are hoping for maps that are less partisan than the maps of the past decade, they are likely to be sorely disappointed in the draft maps under consideration today. These maps do not prioritize sound redistricting principles that experts and the broader public deem vital. Instead, these maps serve first and foremost to perpetuate for another decade the highly skewed maps that we've had in this state since 2011. I'll begin by briefly discussing how these maps fare in terms of compliance with two applicable federal legal requirements, and then I'll spend the bulk of my time addressing whether these maps are faithful to Wisconsin constitutional requirements and whether they advance or fail to advance several broadly accepted redistricting objectives. First, both the U.S. Constitution and the Wisconsin Constitution require districts to be substantially equal in their populations. And here, the draft maps do appear to satisfy that minimum threshold requirement. Second, you've just heard a lot about the Voting Rights Act, and it prohibits map makers from diluting the voting power of communities of color. The act is not the easiest law to understand and apply, and I have not had an opportunity to do the sort of full-fledged functional analysis that the law requires. I will say that these draft maps include several majority-minority districts in the Milwaukee area. There are 5 assembly districts and 2 Senate districts in which a numerical majority of the voting age population is African American. And depending on how you count, there are 1 or 2 assembly districts with Latino majorities. The Voting Rights Act, however, is not about creating majority-minority districts for their own sake. Instead, it is about ensuring that large and politically cohesive minority communities have fair opportunities to elect their preferred representatives. Sometimes that might require more than a majority-minority, sometimes less. If members of a protected group can win elections by joining together with other like-minded voters, a majority-minority district may not be required. In fact, the U.S. Supreme Court has faulted map makers for creating majority-minority districts where they are not needed. Here, it is likely possible to create at least 1 additional Black Opportunity District in the Assembly. And the fact that the Assembly has structured these districts the way they have is at least a questionable feature of the maps. As you've heard, this is likely to get litigated. If it is litigated, a court may conclude that these maps pass muster under the Voting Rights Act, but that result is by no means guaranteed. Now, turning to the Wisconsin Constitution, it appears that these maps have focused less on the geographic requirements of that document and instead prioritized 2 extra legal requirements. The Wisconsin Constitution places several geographic constraints on map makers. Districts must be contiguous, they must be as compact as practicable, and they shouldn't needlessly divide counties and other political subdivisions. With respect to these geographic criteria, these draft maps are mediocre at best. The maps do generally avoid cartoonishly contorted districts, but the districts are less compact than they could be. Researchers with the Princeton Gerrymandering Project analyzed hundreds of thousands of computer-generated legislative and congressional maps for Wisconsin, and a substantial portion of those maps had better compactness scores using established metrics. Many of the maps drafted by the People's Maps Commission also have better compactness scores. And some prior court-drawn maps in Wisconsin have done better as well. In other words, it is doubtful that the districts here are as compact as practicable as the state constitution requires. And the same can be said for the number of county divisions in these maps. It is certainly possible to do better, and to do so without sacrificing any of the other legal requirements. And there's some evidence from the People's Maps Commission that bears this out, and other maps could be readily generated on that score. Now, why don't these maps do better in terms of compactness and respect for county boundaries? At least part of the answer is that these maps appear to prioritize at least two other criteria, namely core retention and incumbency protection. Joint Resolution 63, adopted last month, declared that redistricting plans should, quote, retain as much as possible the cores of existing districts and should, quote, avoid incumbent pairing, so that existing representatives do not have to face off head-to-head. Both of these criteria explicitly tie these new maps to the existing maps and seek to minimize change. The joint resolution describes this as a way to promote, quote, continuity of representation. And in fact, these maps closely resemble the current maps. The average core retention rate for the assembly districts, that is, the extent to which the new districts retain the populations of old districts, is nearly 85%. For the Senate and congressional districts, it's well above 90%. And there are very few incumbent pairings. For at least three reasons, this emphasis on continuity is highly questionable. First, Wisconsin law nowhere instructs mapmakers to defer to prior maps. Instead, these are extra-legal considerations. It's common, of course, for mapmakers to weigh discretionary criteria, but some of these criteria are more legitimate than others, and they are not supposed to take precedence over the legal rules. And here, continuity does seem to have loomed larger than the state constitution's express geographic requirements. This is especially dubious given that the Constitution instructs the legislature every decade to, quote, district anew, which suggests the importance of making a fresh start. Second, although core retention and incumbency protection are sometimes described as traditional redistricting principles, these criteria have not been consistently applied in Wisconsin or elsewhere. They certainly were not applied a decade ago, when the legislature dramatically overhauled the prior maps. A federal court reviewing the legislature's work observed that had lawmakers prioritized continuity, they could have equalized the populations of the then existing assembly districts by shifting just over 300,000 Wisconsinites from one district to another, less than 6% of the state's population. Instead, more than 2.3 million people, 41% of the population, found themselves in new assembly districts. The court described those as striking numbers, and they speak to the reality of these continuity criteria. They are traditional redistricting principles only in the sense that it is traditional for lawmakers to embrace or disregard them as needed to advance other objectives, usually political ones. That points to a third concern about the decision here to carry forward so much of the prior maps. Continuity is valuable only to the extent that the status quo is actually worth preserving, and the existing maps have been widely criticized for their severe partisan skew. It is worth recalling that although the maps did survive the decade, two different federal courts criticized their, quote, sharply partisan methodology, and one of those courts held that the maps were unlawful partisan gerrymanders. The court in Whitford versus Gill found that lawmakers, quote, intended to burden the representational rights of Democratic voters by impeding their ability to translate their votes into legislative seats, and the map has had its intended effect. In the court's words, quote, a focal point of the drafters' efforts was a map that would solidify Republican control and entrench the Republican Party in power. Now, the U.S. Supreme Court in Whitford vacated that Whitford ruling on a technicality, and it later ruled in another case that federal partisan gerrymandering claims are non-justiciable. But the Supreme Court never seriously questioned the district court's conclusion about the partisan nature of the maps, and the court made clear that it, quote, does not condone excessive partisan gerrymandering, which it recognized, quote, can lead to results that reasonably seem unjust. And in fact, the one constant in Wisconsin politics over the past decade has been the tilted legislative playing field. The legislature has remained solidly Republican, even in elections such as 2018, when the state's voters chose Democrats in statewide races. Even when Republicans received fewer overall votes in state legislative races, they have still won more than 60% of the seats in both legislative chambers. All indications are that these draft maps would lock in these imbalances for another decade. In this context, continuity is far from a neutral value. It is instead a euphemism for entrenchment. In my academic work, I use the term gerry laundering to capture instances in which mapmakers seek to perpetuate their favorable position under the guise of continuity. That seems to be what is occurring here. At the same time, these draft maps flout several other redistricting principles that most experts and most citizens would rank well above core retention and incumbency protection, namely partisan fairness, competitiveness, and responsiveness. These three widely embraced criteria were all glaringly absent from the recent joint resolution articulating criteria for district plans. Consider first partisan fairness, a value that a growing number of states have formally enshrined in their redistricting law. It is also a value that's been embraced across Wisconsin by the dozens of counties that have formally endorsed fair maps. These draft maps do nothing to address the skews of the current maps. If anything, they reinforce them. The Campaign Legal Center's Plan Score project analyzed these drafts using 4 different established measures of partisan bias. On every measure, each map rates on par with, or in some instances worse than, the existing maps. And to be clear, the metrics showed a high level of bias in the current maps, both in absolute terms and relative to other states. It's sometimes argued that this partisan bias is an inevitable byproduct of Wisconsin's political geography. That is simply not the case. Wisconsin's geography does lean modestly in favor of the Republican Party, due mainly to the clustering of Democratic voters in the Madison and Milwaukee areas. But Republicans cluster as well, if not quite to the same extent. The reality is that we can readily draw maps that are at least as faithful to geographic requirements and other legal rules, and that do not provide the sort of large and durable advantage that we see in the current maps and in these draft maps. Again, the draft People's Maps Commission maps provide some evidence of this, as does the work of the Princeton Gerrymandering Project. They analyzed the number of seats each party would likely win under hundreds of thousands of randomly generated maps that accounted for geography, and concluded that these draft maps are outliers in the extent of their partisan skew. They attached a grade to their partisan fairness measures, and for each of these maps, that grade was F. These draft maps do no better with respect to competitiveness and responsiveness. By competitiveness, I mean the likelihood of having closely contested races between major party candidates at the district level. By responsiveness, I mean the potential for the balance of power to shift over time as the political pendulum swings back and forth. Competitiveness and responsiveness are vital to a well-functioning democracy. They help to ensure that representatives remain accountable to their constituents and that those who govern us are attentive to prevailing public preferences. These draft maps will likely produce truly competitive races in less than 10% of Senate districts and in less than 20% of Assembly districts. The overwhelming majority of Wisconsinites would live in districts where they are unlikely to have closely contested general elections. Given that Democrats and Republicans both cluster in various parts of the states, we will inevitably have some districts that are quite safe for one party or the other, but it is entirely possible within the confines of our geography to have many more competitive districts than these maps produce, districts that could swing in one direction or the other depending on the political tides. 10 years ago, this body adopted maps that decisively tilted the partisan playing field. Instead of offering more partisan balance, more competitiveness, and more responsiveness, the maps it is considering today would keep that playing field tilted for another decade. Thank you.
Questions from the committee? Senator Royce.
Thank you, Mr. Chairman. We heard testimony from the leadership, from Representative Voss and Senator Lemieux, that the partisan criteria that they were using really were kind of an afterthought, that first they were looking at all these other considerations. Given how these maps perform, do you think it's credible for anyone to assert that partisanship was a sort of secondary or an afterthought consideration in creating these maps?
So I have no insight into the details of their process. I would say that given the biased starting point that they had with these maps, they could have decided first to prioritize core retention and incumbency protection, and only at that stage consider partisanship. So in that sense, it's possible that they formally looked at political numbers only secondarily, but they were able to do that and achieve their goals precisely because of their starting point.
And it's great to have a constitutional law expert here, because I think there are a lot of people who are throwing around legal terms. And one of the things that I heard the bill's authors assert on numerous occasions was that their maps were constitutional. And my understanding is that they have not yet been challenged, and so we can't really say if they're constitutional. We can just look at some of the factors and say, well, courts would be skeptical of this or that. But the idea that these maps are somehow approved by the courts is not correct. Can you speak a little bit to that?
Well, these maps certainly are just in draft form. They haven't been adopted. They haven't been litigated. And so to that extent, they certainly haven't been validated as constitutional by a court.
And if they were going to comport with the Constitution, do you think that that they would need to go through a number of reviews related to the treatment of minority voters under the Voting Rights Act, as well as reviews in how they were created under both federal and state courts?
Yes. I mean, given our history, it's very likely that these maps will get litigated. That litigation will likely be extensive, and there will be a number of issues that will get explored in detail, including the Voting Rights Act issues, including very likely issues of state law concerning some of those geographic criteria that I mentioned.
Thank you. Thank you. I'm Representative Pope.
Thank you, Mr. Chair. I appreciate your testimony here this morning. If you were in the room earlier, you probably heard Representative Voss's testimony.
I heard a little bit of it remotely.
Okay. Well, there was a reference made to the attempt to delay the entire election process due to the pandemic. I don't think he attributed it to why, but the pandemic certainly messed with the census-taking situation and process. Had that happened, and we would have delayed the map making until after the next gubernatorial election, wouldn't it be fairly easy to assume that the whole thing would be done in order to have a different governor in the East Wing? And if those maps then were signed by a Republican governor, they would be immediately affected. Is that right?
So I don't want to speculate on any sort of political calculations that might go on, but if the question is just if maps are drawn when there's unified government, if there were a Republican governor, then yes, presumably that governor would be more likely to sign whatever maps the majority here produced.
Okay. And then are you able to speak to the ability of counties, county boards, to, because the pandemic affected us all, and we knew that there was going to be some delay, in order to squeeze down the process and meet the requirement to have their work done in time? Does it seem to you that that was a very big problem for counties?
And this is certainly an issue not just here but across the country because the census data did arrive late, and I think that here and throughout the country people have to work a little bit more quickly than they usually do, but my sense is that the process is proceeding basically everywhere.
I haven't heard of any counties who are just finding it, who found it impossible to do or even that difficult.
I'm not aware of any specifics there.
Thank you.
Representative McGuire.
Thank you, Mr. Chairman. And I don't want this to go on too long. I don't want you to reiterate your entire testimony. We certainly appreciate you being here today. But I don't have a written testimony in front of me. So we heard a lot today about this least changes principle, and it sounds like from your testimony that principle isn't typically a priority in map drawing. Can you discuss that a little bit further?
Sure. So first I'll say it is not a legally enshrined principle in the same way that other traditional redistricting principles are. So nearly every state, including Wisconsin, has in their state constitutions or statutes geographic constraints on the districting process, things like compactness and keeping political subdivisions together. There are virtually no states, Wisconsin included, that have similarly elevated these notions of continuity, core retention, or incumbency protection into their laws. Across the country, I think there are a grand total of 3 states that make any reference to core retention. There are no state laws anywhere in the country that promote incumbency protection as a value. So they don't. Those criteria don't stand on equal footing relative to things like the geographic criteria that we've discussed. In practice, maybe partly because they are discretionary criteria, they are applied haphazardly, and usually only when they serve other objectives. So they're disregarded when convenient, and they're embraced when convenient. And in that sense, these criteria are no different from some of the political criteria that you could call traditional, in the sense that people traditionally do think about them, but not traditional in the sense that these are redistricting values that we really want to embrace.
So, Mr. Chairman, can I ask a follow-up question?
Yes.
Thank you. So you're a law professor. Do you know if the court cases in 80 and 90 and in the past, have they incorporated any of this lease changes principle into the development of those maps?
With respect to leased changes, the answer is no. So leased changes is, as that term implies, you take the existing map and you make only the minimum adjustments needed to restore population equality. And that's not what the courts did in the 80s, 90s, or 2000s. What courts here and elsewhere sometimes will do is they will give some consideration to those prior boundaries. And across the country, there's actually quite a mixed practice on this. There's no standard across the courts. More often than not, I would say they do not embrace a least change approach. And in those instances when courts have ultimately used the prior map as their template, typically they first assure themselves that the prior map does not have a particular skew. So it is most common for courts to think about continuity as a relevant value when the maps that they are creating are adjusting maps that were themselves court created. So I could not point you to any instances in which courts have said that continuity is a value that we should prioritize when there are serious flaws with the prior map.
Senator Royce.
Thank you, Mr. Chairman. You used a phrase, I think you coined it, that I had not heard before, and I think it's really clever, Jerry laundering. I guess like money laundering. And one of the things that we see here in Wisconsin is that the legislative Republicans are often drawing on ideas that Republicans in other states have tried, both in terms of public policy as well as political efforts. So can you talk a little bit about the Jerry laundering that's happening here in Wisconsin in the context of what you might have seen around the country with efforts to re-gerrymander again nationally?
Sure. So this is something that exists not just in Wisconsin, but as many of you know, in 2010, there was a lot of active gerrymandering that took place in a number of states. And thanks to technology, thanks to better data, thanks to the fact that our citizenry is more divided along partisan lines than before, that gerrymandering can be more powerful and durable than it's often been in the past. And so that means now, a decade later, it's coming time to redistrict in many of those states that had gerrymandered maps last time around. The people who created those maps are often still in power. And so while they may have overhauled those maps last time around to achieve their objectives, this time they see that an easier way perhaps to achieve their objectives is simply to stay the course and embrace the status quo, which has worked quite well for them for the past decade.
Rep. Olmsted.
Well, thank you, Mr. Chair, and thank you for your testimony today. I think you were in the room earlier when I asked Mr. Sutta in terms of what the criteria that the federal courts used or found in when they ruled that the last gerrymandered map was indeed unconstitutional. Can you go through what you see as the important criteria there?
Well, so if you're talking about Whitford versus Gill, the test that the district court used in that case was a 3-part test, where they first asked whether there was a partisan intent behind the maps, whether they were adopted for the purpose of tilting the playing field, and it concluded that the answer to that question was yes. The court then considered whether there was a discriminatory partisan effect. Did the maps actually achieve what they intended? There, too, the court answered yes. And then third, it considered whether there was any legitimate neutral justification for the partisan skew. And one of the justifications offered was the political geography of Wisconsin. I believe the court might have considered some others as well. And it concluded that there was no legitimate basis for the discriminatory nature of the maps.
Thank you.
Thank you for your testimony.
Thank you.
Next up is Matt Rothschild, Wisconsin Democracy Campaign, speaking against.